Housing Rights of Domestic and Sexual Violence Survivors. My name is Malia Schultzman, and I'm an attorney at the National Housing Law Project in San Francisco. The National Housing Law Project is a national technical assistance provider to Office on Violence Against Women, OVW grantees. What that means is that we're here to support you in all of the great work that you're doing on behalf of survivors. So anytime that you have a housing-related question, feel free to call or email us. And you'll see on the last slide of this presentation is our contact information. I'm also very fortunate to be joined today by Sandra Park, who is an attorney at the ACLU Women's Rights Project and a national expert on the fair housing rights of domestic and sexual violence survivors. So, hello, Sandra.
Hi, thank you.
And ACLU also has a variety of great materials and resources on housing rights of domestic and sexual violence survivors. So with that, I'm going to go over a few housekeeping issues first, and then we'll get into the substance of our presentation. So first, I'll show you the GoToWebinar interface. On the left-hand side, you'll have a webinar viewer, and on the right, you have a control panel. Today, everyone is muted during our presentation. So if you have questions, we encourage you to submit them throughout the presentation via the questions box, which is on your right. At the end, we'll go ahead and take some of those questions that you submitted via the question box. For audio, you can choose to either use your telephone or your computer's mic and speakers to listen in. And we encourage you to use the telephone if you're having any issues with audio quality. All right, so some other housekeeping issues. The materials for this webinar were emailed to all registrants before the webinar, and we'll also email them out again after the presentation, along with an online evaluation. We do encourage you to complete that evaluation. Your feedback is always really helpful for us to improve our future webinars. We will post the materials and the recording of this session on our website, and those should be up by the end of next week. Finally, for those of you who are California attorneys and are seeking MCLE credit, your certificates will be emailed out to you probably by the end of next week. So at this time, we wanted to run some polls and see who is in the audience with us today. So the first question is, which best describes you? Are you a housing advocate or attorney, a domestic violence and or family law advocate or attorney, a sexual assault advocate or attorney, federal, state, or local government employee, or other? And so I'll give you a little bit more time to answer the question, and then we'll see who's joined us today. Okay, and so I'm going to share the results. It looks like 24% of you are housing advocates or attorneys, 60% are domestic violence and or family law advocates or attorneys, 3% are sexual assault advocate or attorneys, and 13% fall into the category of other. And so I'll move on to our second poll now, and I'm going to ask you, how would you describe your knowledge of fair housing rights of domestic and sexual violence survivors? Would you say that you're very knowledgeable, somewhat knowledgeable, or would you say that you are new to the topic? So I'm just waiting for people to vote. And it looks like 7% of you would describe yourselves as being very knowledgeable. About half would say that you are somewhat knowledgeable about today's topic, and 39% are new to this topic. So we have a great mix of experiences and backgrounds on today's call. So I now want to move on to an overview of what we're going to cover today. First, we're going to start off with some case examples of how the Fair Housing Act's protections arise in the context of domestic and sexual violence. We'll then go into the law and discuss the fair housing protections that are available for survivors of domestic violence, sexual assault, and stalking. We'll then move on to go back to the case studies we're going to discuss at the beginning of the webinar and talk about the advocacy strategies that were used in those cases. I do want to clarify that we are not going to cover the housing provisions of the Violence Against Women Act, or VAWA, today. Those provisions apply to survivors in public and Section 8 housing. The reason why we're not going to cover those protections is that they were discussed in a prior webinar. And that webinar, the materials and recording are available on our website. And also there are a lot of resources available on VAWA on both our website and the ACLU Women's Rights Project website as well. And if we have time at the end, we're certainly happy to answer some questions regarding VAWA. So with that, I'm going to move on now. And we wanted to give you a few case examples that really illustrate how these cases arise. What are the sorts of facts that I'll call into question the fair housing rights of domestic and sexual violence survivors. So the first case example I'll talk about, I'll call the client Jane. And Jane was a Section 8 voucher tenant. She had received a subsidy from her local housing authority and was renting a private housing unit with that subsidy. Unfortunately, her ex-boyfriend frequently came to the unit and harassed her and assaulted her on some occasions, and it became clear that she was no longer safe in that unit. So she requested that the housing authority allow her to take her voucher and move out of state so she could protect herself. The housing authority started asking Jane some questions about letting her move and take the voucher with her. And they told her that in order for her to move, she'd have to get the landlord's permission to end the lease early because she still had an existing lease with her landlord. And unfortunately, she wasn't able to get the landlord to agree to that. And there were still more incidents of violence, and she came back to the housing authority and asked again if she could please be allowed to take her voucher and move out of state. And the housing authority said, we'll consider it, but you need to provide a police report documenting each incident of violence. And Jane provided those police reports to the housing authority. Unfortunately, one of the police reports mistakenly stated that the abuser was living with her, and the housing authority saw that and automatically said, we think you have an unauthorized person living in the unit. We saw it in the police report, when really it was a misunderstanding where the police had just assumed that the abuser was living there. And as a result, the housing authority basically told Jane that they thought she had committed a violation of the Section 8 program rules by allowing this person to live there without the housing authority's permission. And so we'll come back to Jane's case at the end of the webinar, and we'll talk about the approaches that her attorney used to try and stop this voucher termination, and also what he did later on when the housing authority actually did go through with the termination. The next client I'll talk about is Kathy. And Kathy resided in private rental housing, and it was operated by one of, I think, the largest national property management company in the country. And she lived there with her fiance and her daughter. Unfortunately, after moving into the unit, Kathy's fiance, his behavior became quite erratic, and he became increasingly abusive toward her and even sexually assaulted her on one occasion. And so as a result of that, Kathy knew it was no longer safe for her to live there with her children in that unit. And so she asked the housing provider, the management company, if she could take him off the lease. The other thing that she did is she sat down with her fiance and told him basically, I need to end our relationship. Unfortunately, he became very violent when she had this conversation with him, pointing a gun both at her and himself, threatening to kill her and himself if she did not stay with him. So she was forced to call the police. She had her fiance arrested, and she did press charges against him. And she, again, informed the management that she wanted to remove him from the lease agreement. And additionally, she obtained a restraining order. Unfortunately, after Kathy notified the housing provider of what had happened in the unit and showed them the copy of the restraining order, They then served her with an eviction notice as a result of the criminal activity by her fiance. And attached to the eviction notice was actually a copy of her restraining order, which seemed really, really unfair, obviously, because she had sort of done everything that she could do to protect herself and everything that we would typically recommend that a survivor do in this type of case. So at the end of the webinar, we'll come back and we'll discuss what Kathy's attorneys at the Shriver Center did on her behalf. And so I now want to turn it over to Sandra to talk about a case that she's very familiar with.
Sure. So the next case study is the case study of Tanica, who was living in an apartment that had been developed with low-income housing tax credits, which is a part of a federal program to help local developers develop apartments for low-income families. Tanica had been subjected to abuse from an ex-boyfriend and so had obtained a restraining order of which she notified the management company. Following that, while she was away at work, her ex-boyfriend actually came to the home and broke in, kicking in the door and breaking the windows, and he was arrested for home invasion from that incident. After that, the property management company sent Tanica an eviction notice and cited the provision in her lease that said that she was responsible for damage caused by her guests, and basically was framing the whole incident as her ex-boyfriend having been her guest, and therefore Tanica being responsible for the damage he had caused.
All right. So we'll come back, and Sandra will tell you what happened in Tanica's case at the end. But for now, what we're going to do is we're going to do a very quick overview of the basic provisions of the Fair Housing Act, and then Sandra will get into more detail about how Fair Housing Act rights intersect with domestic and sexual violence. And this is going to be a quick overview. I know that some of you are very knowledgeable on this topic already, so if during this time you want to share some great practice tips, some quick practice tips on how you use the Fair Housing Act, or if you want to share some helpful resources for those who are just getting started, you can go ahead and do that through the questions box. So Fair Housing Basics. This is a federal law that prohibits discrimination in the sale or rental of housing on the basis of someone's race, color, national origin, religion, sex, familial status, and disability. And today we'll focus a lot on sex discrimination under the Fair Housing Act. And we'll also touch on race discrimination and national origin discrimination as well. There are two overarching theories that are often used to assert fair housing rights, and those are intentional discrimination, which is often referred to as disparate treatment theory, as well as disparate impact theory. And we'll talk about how those types of theories play out in domestic violence cases. I really wanted to talk about the scope of the Fair Housing Act. It covers most dwellings, except there are some exceptions. I won't go into them in too much detail. Just in general, it's good to know that some property owners who don't own very much property at all may not be covered by the Fair Housing Act. But another thing that's important to note as well is that many states have fair housing laws of their own that are sort of counterparts to the Federal Fair Housing Act. And those state laws may be more protective than the federal law. And so even if you have a client who is not protected by the Fair Housing Act, perhaps because she falls into one of these categories, she still might be covered by your state fair housing laws. So touching on Fair Housing Act theories. The first one I want to talk about is disparate treatment theory. And this is where a housing provider intentionally discriminates when it treats people differently because of their membership in a protected group. In other words, treats them differently because of race or sex or national origin or the other categories we just talked about. So some examples of behavior that's prohibited under the Fair Housing Act include communications or advertisements that indicate a preference as to a protected group, such as maybe an ad on Craigslist from a landlord seeking to rent a unit and says, Asian tenants preferred. refusal to rent to someone or provide them a housing benefit because of their race or sex or national origin would be prohibited under the Fair Housing Act. Offering someone different terms in a rental agreement based on their sex or gender or race would be considered discrimination under the Fair Housing Act, such as steering someone of a particular race to a particular building that the property owner has. Finally, harassing or evicting tenants because of their sex or race or national origin or other protected characteristic is prohibited under the Fair Housing Act. So that's disparate treatment theory. The other type of theory that we'll talk about today is disparate impact. And this occurs when a policy is neutral on its face, but has a disproportionate impact on one of those protected classes we've talked about. So for example, a landlord might have a policy requiring all housing applicants to demonstrate that they have a certain level of income in order to qualify for housing. And that policy might also state that the landlord does not consider regular child support payments as income. Even though that policy is facially neutral and doesn't talk about sex, for example, it could still have a disparate impact on the basis of sex because a significantly higher proportion of child support recipients are women, and more women would be disadvantaged by that policy than men. Something to note is that statistics are vital to demonstrating disparate impact. In the example I just cited, you would, of course, need to provide some statistics showing that women, that a significantly higher proportion of child support recipients are women. And Sandra will actually talk a little bit about some of the statistics that are used in domestic violence and fair housing cases. I want to close up this quick discussion of the Fair Housing Act by just touching briefly on enforcement mechanisms. And I'll talk about affirmative litigation and HUD administrative complaints. So first, with affirmative litigation. There's a 2-year statute of limitations under the Fair Housing Act. And so it's critical, once the discriminatory act has occurred and you hear about it from a client, to refer them quickly to pro bono attorneys, just so that they're able to assert their rights before the 2-year period ends. As I mentioned, I'm going to talk about HUD fair housing complaints. Affirmative litigation can be filed concurrently at the same time with a HUD complaint, but you're not required to first seek relief through a HUD complaint before filing affirmative litigation. It's not required by the statute. These cases are brought in both state and federal court. And some of the relief that's available to victims of housing discrimination include compensatory damages, injunctive or equitable relief, punitive damages, and attorney's fees. So there are a variety of remedies available. The other major type of enforcement mechanism we'll talk about is using a HUD complaint. And this is an administrative process. Individuals can file complaints with HUD. It's important to note that there is a 1-year statute of limitations, a relatively short period where you need to exercise your rights if you've experienced housing discrimination. The complaints can be filed quite quickly. There's a couple of methods. They can be filled out online, sent in by mail to a HUD regional office, or HUD will also do phone intake. HUD has a duty under the law to attempt to settle any fair housing complaints that it receives. And if the attempts to settle fail and HUD finds cause to believe that discrimination occurred, the next step is to either refer the complaint to an administrative law judge, or the Department of Justice can bring litigation in federal court. The types of relief that are available under the HUD administrative complaint process are compensatory damages, injunctive or equitable relief, and civil penalties. And here I've included a link to the website where you can find out more about how to file a HUD complaint and the procedures that are available for doing that. So with that, now that we've had a quick, broad overview of the Fair Housing Act, I'm going to turn it over to Sandra so she can discuss how the Fair Housing Act specifically applies to domestic violence survivors.
So for years, there were several cases brought under the Fair Housing Act on behalf of domestic violence survivors using both of the mechanisms that Malia just outlined, both as affirmative litigation cases as well as HUD complaints. And that precedent helped bring about this recent memorandum that was issued by HUD's Office of Fair Housing and Equal Opportunity. This is a new guidance that just came out last month, and it's available on HUD's website. The link is right there, and I encourage all of you to read it. It's also included with the webinar materials if you're interested in these issues and a case comes up. The guidance is wonderful in that it affirms HUD's commitment to using the Fair Housing Act to protect victims of abuse from discrimination in housing. And there's a great quote from Assistant Secretary Trevina to that. Now, the memorandum talks about several different things, but in terms of background, it provides statistics about domestic violence, sex, and race that would be relevant to a housing discrimination analysis. So some of the statistics listed are that women are 5 to 8 times more likely than men to be victimized by an intimate partner, that 85% of victims of intimate partner violence are women, and of course that's all relevant in terms of a sex discrimination claim because of the disparate impact theory, that if there's a policy that is targeting domestic violence survivors, the fact that women are disproportionately affected by domestic violence factors into a disparate impact analysis. Also, HUD cites the fact that black women experience intimate partner violence at a rate of 35% higher than white women, and that Native American women are victims of violent crime, including rape and sexual assault, at more than double the rate of other racial groups. Now, in terms of how the domestic violence component feeds into the fair housing theories, one thing that you have to keep in mind is that domestic violence survivors are not specifically a protected class under the Fair Housing Act or most state fair housing laws. So those laws typically protect against discrimination based on race, sex, national origin, familial status, and other categories. But domestic violence or gender-based violence is not one of those. So typically advocates have used the disparate impact theory, which has been used to challenge neutral policies that have the effect of treating domestic violence victims more harshly. And again, that has to do with the fact that domestic violence victims are more likely to be women, and thus there's a disparate impact on women when there are policies that harshly treat domestic violence survivors. There's also the disparate treatment theory as applied to domestic violence, which has been used to challenge actions that were taken against a tenant because of stereotypes regarding domestic violence. And some of those stereotypes are stereotypes about the domestic violence survivor's responsibility for the violence she experiences. And I'd encourage you to look at the HUD memo for their discussion of that. For example, they cite a situation that if a landlord tells a female domestic violence victim that he does not accept women with a history of domestic violence because they always go back to the men who abuse them, that statement would be direct evidence of a stereotype and constitute sex discrimination under the Fair Housing Act. The other aspect that the memo discusses is that oftentimes both of these theories are in play when a survivor is facing housing discrimination. And so you can cite and allege both of these theories depending on the facts of your case. So I think we're going to move on to a discussion point, and here our question for you all is, what are some policies and practices that housing providers use that may have a negative impact on survivors of domestic and sexual violence? And if you want to take a minute and enter any examples that you can think of in the chat box, that would be great.
All right, so we'll take a couple minutes here and just give you all a chance to brainstorm and tell us what are some of the policies that you have seen housing providers use that had a negative impact on your clients.
Okay, so
Okay, so I'll just go through a couple of these. Somebody has mentioned automatic eviction for any criminal activity. You know, a failure of the housing provider to distinguish who was the victim of the criminal activity and who was the perpetrator. Somebody has said that one policy that has a negative impact on survivors is evicting someone for having an unauthorized guest, not allowing a person to be removed from a lease because of domestic violence, holding victims responsible for damages, disturbing the peace violations, stringently, when somebody applies to housing, stringently reviewing their credit history from the past when the survivor was still involved with the abuser. Again, I see somebody saying evicting them for criminal activity when the activity is that of their abuser. Evicting the victim based on the neighbor's complaints of violence. Somebody says tenants are held responsible for damages done by a guest. A domestic violence perpetrator should not be a guest, especially if there's a protective order in place. Somebody mentions a term in the lease that states that if law enforcement is called to the scene too many times, then the tenant will be evicted. I think, yeah, so sadly there are a lot of examples that you all have provided regarding negative policies that you're seeing that have a really harsh impact on domestic violence survivors. So I'll turn it back over to Sandra to talk some more about discriminatory policies.
So we actually listed some here, which I think are almost all covered by your comments. The ones that we've seen commonly include evictions under zero tolerance for crime policies, which I think are very common lease terms that tenants have. Evictions for property damage. So again, where the property damage is caused by the abuser, there are often problems faced by the victim who is then held responsible for that. The refusal to rent to an applicant because of criminal history or poor credit history related to domestic violence. And we know that for many domestic violence survivors, there may be a criminal history in their own background because of self-defense or self-defense situations, as well as poor credit histories if abusers were involved in complicating their credit history or otherwise controlled their finances. Also, the refusal to rent to an applicant because of stereotypes about survivors. So the stereotype that was cited in the HUD memo that I referred to, we've also heard about situations where survivors have been refused rentals simply because they had an order of protection. So the fear that somehow the fact that someone has had an order of protection, that they decide to take one out means that the danger will follow them or somehow complicate the tenancy at a particular property. And the refusal to break a lease early in order to allow a person to escape an abusive situation. And this is a very difficult situation for many survivors who, in states where a tenant is liable for the rest of the lease term, even if the landlord is able to find another tenant, this can be incredibly financially burdensome for a tenant who wants to leave the lease early because of the safety situation. So we wanted to talk a little bit about the disparate impact analysis because I think that is often the more common theory that might come up in these cases. And HUD has a pretty good analysis of the 4 steps that they are going to engage in when they receive these complaints. First, the first question they're going to ask is there a discriminatory policy, practice, or procedure? And so that can be any of the ones that we listed above or the ones that you had listed in the chat box. So basically trying to identify what is the policy or practice that's at issue. Second, was that policy, practice, or procedure consistently applied? And the reason HUD asked this is because if the policy was not consistently applied, for example, let's say it was only applied as to, let's say there's a zero tolerance for crime policy, but it's really only applied as to domestic violence survivors, but not applied to other crime victims, there may also be a claim of unequal treatment, that it's not really an issue of disparate impact, it's an issue that the landlord is unequally treating victims and survivors of domestic violence by selectively applying the policy that he or she has on zero tolerance for crime. So that's a key question for the HUD. And once you have an unequal treatment claim, that becomes a disparate treatment claim. It takes itself out of the disparate impact analysis. Let's say it is a policy that's being consistently applied. The next question for HUD is, does the policy have a disproportionate impact on women who are victims of domestic violence? And this is where the statistical analysis comes in. HUD talks in any disparate impact analysis, HUD will engage in statistical analysis. In the context of domestic violence, they're going to be looking at what statistics say about how the policy is being applied and how it affects women. So, for example, there may be a zero tolerance for crime policy that's at issue. And one set of statistics HUD will be interested in is to see whether under that policy women are more likely to be evicted than men. So the statistics about who's getting evicted under this policy, are there more women being evicted in proportion to the women who are tenants? And is that related to the fact that the evictions are based on domestic violence? That's just one example of the kind of statistic that might be relevant. It really depends on what the policy or practice is that you're looking at. The fourth step that HUD engages in terms of disparate impact analysis is they ask, is there substantial business justification with no less discriminatory alternative? So that means that the landlord or PHA has to come up with a substantial business justification for what this policy is. So although the policy might look neutral on its face, once you see that there's a disproportionate impact on women because of the way it affects domestic violence survivors, the landlord then has the burden of saying, what is their substantial justification for this policy? And also, are there other less discriminatory alternatives? For example, in the zero tolerance for crime policy arena, it may be that we see that there's a disproportionate impact on domestic violence survivors. And the landlord says, well, our justification is that we need to deal with crime on our property, including domestic violence. Well, the next question is, are there less discriminatory alternatives? Because the way you're applying this policy also penalizes the victim. Are there things you can be doing to take care of the issue of domestic abuse occurring on the property, including taking action against the alleged perpetrator without penalizing the victim? And so that's a key part of the analysis, really thinking through whether there are other options for landlords other than the discriminatory policy. I also wanted to raise some other questions that HUD discusses in their memo, which I think are really important to think about when dealing with clients. And they talk about whether policies, practices, or procedures that discriminate against survivors of domestic violence, dating violence, stalking, or sexual assault could also be considered discrimination on the base of race or national origin. So what we've primarily been talking about here are sex discrimination theories because the majority of domestic violence survivors are women. But as the HUD memo also noted in its statistics section, many domestic violence survivors, a disproportionate number of them, are women of color, as well as immigrant women, and also that Native women face much higher rates of sexual assault and rape. And so HUD is raising the question here, for those women, could it be that policies that are discriminating against survivors of domestic violence and other forms of violence are also discriminatory based on race or national origin? I'll mention for discriminatory policies that are occurring on tribal land that the law that we've primarily talked about here, the Fair Housing Act, is a federal law and actually does not apply in Indian country. So with respect to Native women, all of this analysis would apply outside of tribal lands, but on tribal land, the Fair Housing Act does not apply. And so if you have situations on tribal land that you would want to have further investigated, please feel free to reach out to Malia and myself. The other question I wanted to raise here, which HUD does not really address in its memo, is that the memo really discusses domestic violence. And I think a lot of the same analysis in terms of disparate impact would also apply to other forms of gender-based violence like sexual assault. And so that's something that needs to be kept in mind when you're dealing with survivors of sexual assault and other gender-based violence crimes. Lastly, I want to mention that there are other state and local laws that also can apply in the domestic violence arena. And this is something that we've often used, where we will look to the state and local fair housing laws because they often contain the same or sometimes broader protections than the Federal Fair Housing Act. And in particular, some jurisdictions have enacted housing laws that do include domestic violence survivors as a protected class under their fair housing law. And the National Housing Law Project has a really great state law guide that basically catalogs all of the housing laws relevant to survivors, and that law guide is available at that website that's listed. And there's also an example listed there from Washington State, of Washington State's law that specifically provides protections for victims of domestic violence, sexual assault, and stalking in the housing context. And so that's an example of a state law where domestic violence, sexual assault, and stalking are recognized as a protected class. And that's advocacy that many domestic violence and sexual assault providers are interested in doing in other states, and something you should consider if you think there's a need for it in your state.
All right.
So now I think I'm going to move, yeah, so, okay.
Yeah, go ahead. Great. So we did want to take some time to focus on sexual harassment in housing. We recognize that this is a problem that many of you are encountering, and we also want to recognize that fair housing laws may provide remedies for tenants who have been subjected to this at their rental housing. So first of all, sexual harassment in housing is a form of sex discrimination that's prohibited by the Fair Housing Act. And so we wanted to hear from all of you about what are some examples of sexual harassment in housing that you've heard of or that your clients have reported to you. And if you could just share those in the questions box, and we'll give you a couple of minutes to do that. But our purpose is just to give everyone examples of what sexual harassment in housing might be or might look like. Okay, so I see some things coming up in the question box, so please keep entering those. But I see one person saying that landlords visit, quote unquote, without invitation. In other words, enter the tenant's unit without the tenant's permission, which can be quite invasive and intimidating for a tenant. Another attendee is saying a landlord exchanges sex for lower rent. Another attendee says rape by a landlord, followed by eviction of the victim, probably to prevent her from reporting. Somebody's mentioned the landlord asked neighbors to monitor a woman's activity. Somebody says the landlord says the tenant doesn't have to pay rent if she sleeps with him. Similarly, someone mentions the landlord agrees to reduce the rent in lieu of the tenant providing him with sexual favors. And I should note this could be the landlord or this could be an employee at the property. Yes, I see several people are mentioning lowered rent or covering things like utilities in exchange for sex. Somebody else mentions a landlord threatening eviction unless somebody provides sexual favors or calling a tenant names that are sexual in nature. Somebody mentions a landlord comments on the personal appearance of the tenants or guests or their children. Name calling, things of that nature. Inappropriate touching and comments by landlords or tenants. Somebody says a peeping landlord. So it sounds like, unfortunately, you all are very familiar with some examples of what sexual harassment in housing can look like. And, you know, we came up with our own examples. These very closely mirror what you all have already said. So in terms of what the courts have done in recognition of sexual harassment and how they characterize it, courts recognize two basic forms of sexual harassment. The first is quid pro quo, and that's when a provider, employee, or agent conditions access to or retention of housing on a tenant's submission to sexual conduct. And that's the example that many of you cited where a landlord says, I will lower your rent, or I'll waive your rent if you have sex with me, or I won't provide maintenance for you at the unit unless you do this favor for me. The other major theory of sexual harassment that courts have recognized is hostile environment. And under hostile environment, a provider, employee, agent, or in certain circumstances, another tenant engages in sexual behavior that is either so severe or so pervasive that it alters the terms and conditions of the tenancy, and it creates an environment that is intimidating, hostile, offensive, or otherwise significantly less desirable. And HUD has clarified that from their perspective and from their position, hostile environment theory, it's based upon the perspective of a reasonable person in that tenant's position. It's not just the reasonable person standard. It is, would this environment have been hostile to a reasonable person who was in that tenant's position? One other thing that I want to note about hostile environment is that HUD has clarified that the sexual behavior can be severe or pervasive. There's not a requirement that it be both severe and pervasive. In other words, that it be both severe and that it happened on multiple occasions. It could be one or the other. In terms of who is liable for sexual harassment, HUD has put out what's called its questions and answers on sexual harassment, and we've included the link here. And they talk a little bit about how does one become liable for sexual harassment. HUD notes that sexual harassment doesn't have to be motivated by sexual desire. It can actually be motivated by hostility toward a particular sex, even if the harasser is the same sex as the victim. So, for example, if there is an employee at a housing project who is male and whose sole purpose is to embarrass, humiliate, or intimidate gay men, that could be considered sexual harassment under the Fair Housing Act, even though there might not, it might not have been motivated by sexual desire, and even though the two parties are of the same sex. A property manager or owner, according to HUD, has a duty not to engage in sexual harassment and also to ensure that its employees do not engage in sexual harassment. HUD has said that owners can be held either directly or vicariously liable for sexual harassment. So in other words, owners can be held responsible for harassment that occurred without the owner's knowledge by an agent or employee of the owner. And HUD cites as an example, if a landlord authorizes a maintenance worker to enter a tenant's apartment and make a repair, and that worker sexually harasses the tenant, the landlord could be vicariously liable for the worker's sexual harassment just by authorizing that worker to enter the tenant's unit. And so Sandra's going to discuss a case that she has familiarity with that illustrates some of the problems raised by sexual harassment in housing.
So the case I'm going to talk about is Boswell, which was brought in Alabama. And Ms. Boswell was a Section 8 voucher holder, and she had rented an apartment, and the real estate agent for that apartment demanded rent beyond what she was obligated to pay under Section 8 unless she provided him with sexual favors. And so when she refused to do so, he then attempted to evict her. And at that point, she decided to bring a federal lawsuit alleging sex discrimination under the Fair Housing Act. And after that lawsuit was filed, many more tenants actually came forward complaining about the same conduct from that real estate agent. And ultimately what happened was the Department of Justice chose to file a separate action against the multiple landlords who had used that real estate agent under that same theory of vicarious liability that Malia just discussed. Ms. Boswell's lawsuit ultimately resulted in a court order against the real estate agent as well as the landlord for damages relating to the sexual harassment she had experienced. And if you're interested in learning more about the case, there's information at that website listed there.
Thanks, Sandra. And so I wanted to bring up one other example, which is United States versus Veal. And this was a case in which a landlord demanded sexual favors from tenants and evicted some who denied his advances. And one resident actually testified that the landlord forced her to have sex twice, once in the presence of her children. Most of these victims were targeted because they were low-income single mothers who had very limited housing opportunities, had no place else to go besides their current living situation. The Department of Justice did prosecute the case, and a jury awarded damages totaling $1 million to 11 residents. And the court upheld this jury verdict, and the cite to the opinion is there. One thing that I wanted to illustrate with the Veal decision is that it shows the real impact on tenants and also why special outreach and advocacy might be needed in these cases. First of all, vulnerable low-income tenants are often victims of sexual harassment. One of the tenants in the Veal case testified that I desperately needed a place to stay, I didn't have anywhere to go, and my Section 8 was about to expire. Second, another important thing to recognize about these cases is that sexual harassment in housing is very difficult for these tenants to disclose. One tenant testified that she was really trying to prove that I was a big enough person to go out there and find something and be responsible for something. Again, someone who was low income and vulnerable and didn't want to have to tell someone that, again, she had difficulty finding appropriate housing for herself and her children. After the sexual harassment, many victims move to substandard housing or become homeless. One plaintiff testified that with no other place to go, she had to move into her mother's 3-bedroom house, which she then shared with 13 other people. And finally, the harassment has lasting effects. One plaintiff said that she thought about the abuse all the time and suffered from nightmares. As a result of these factors, it's HUD and also fair housing agencies have told us that special outreach and partnerships are really needed in these sexual harassment cases. Fair housing advocates have told us that it's important if somebody can come along when interviewing these tenants who has experience in counseling victims of violence and sexual crimes. Other things that fair housing advocates have noted is that the typical outreach of putting out pamphlets or public service announcements might not be enough in these cases. It might be something where emergency shelter workers or domestic violence shelter workers need to include questions about sexual harassment in their intake, or just become more aware of it so that they can tell tenants that you have recourse if this has happened to you. So that wraps up what we wanted to cover on sexual harassment. And now we're going to go back to the case studies we talked about at the beginning of the webinar and tell you about the strategies that were used in each of them. This is also a great time to submit questions about anything that we covered today, and we'll take those questions at the end of the presentation. So if you remember, the first client we talked about was Jane, who had a Section 8 voucher that she wanted to port out of state. And when the Housing Authority asked her for proof of domestic violence, she gave a restraining order that unfortunately incorrectly stated that her abuser was living with her in the Section 8 assisted units. And as a result of that, the Housing Authority sought to terminate her voucher. And Jane's attorney sent a letter to the Housing Authority demanding reinstatement of her voucher. Her voucher was actually terminated after an informal hearing. And the Housing Authority refused to reinstate the voucher. And her attorney then decided that the next best course of action was to file an administrative complaint with HUD to challenge the voucher termination. And we have a portion of the administrative complaint here that was filed. And what Jane really tried to argue is that the notion that she was being terminated for having an unauthorized person in her unit, it was really a pretext for discrimination. The Housing Authority was really the underlying issue was to terminate her for seeking legal and police protection for the domestic violence at her dwelling. And part of the concern that Jane raised was that she had been required to provide numerous examples of documentation just to show that the perpetrator did not live with her. And she was not aware of any other tenant being treated that way and being required to provide such substantial documentation that someone did not live with them. And as a result of that, she argued that she's really being singled out and that the unauthorized occupant issue is just really a pretext for domestic violence discrimination. HUD investigated Jane's claims that the Housing Authority had violated the Fair Housing Act. And the parties had conciliation discussions, and the Housing Authority did later agree to reinstate her voucher and allow her to move out of state. The conciliation agreement included a requirement that the Housing Authority receive training regarding the Fair Housing Act. So I think the bottom line, the takeaway point from this case, is that it's an example of an instance in which a fair housing complaint was used, the administrative process was used to help reinstate a survivor's voucher after she was terminated on reasons that seemed to indicate that there was some sort of discrimination going on based on her status as a domestic violence victim. One thing that I want to note about the case is that Jane had also argued to HUD that its refusal to allow her to port the voucher out of state violated the Violence Against Women Act, or VAWA. And HUD did not really focus on that portion of her complaint at all. Their fair housing investigators were really mostly interested in the sexual harassment, the sexual discrimination claims under the Fair Housing Act. And so that really illustrates the importance of raising multiple theories on behalf of your client when they're available. I want to turn now back to Kathy's case. And if you'll remember, Kathy was the tenant living in private housing whose fiance became quite abusive. And she had called the police on one evening to protect her. And shortly after that incident occurred, the housing provider sought to evict her. As a result of the threatened eviction, Kathy had to relocate. And it really affected her life in several ways. First, she wasn't able to send her daughter to the school that she wanted to send her to. And the new community that she moved to was significantly more expensive than the rent she was paying at her former home. And to address, these injuries, her attorneys filed a lawsuit in federal court alleging both intentional discrimination and disparate impact theory together. So I've included an excerpt from the complaint, and this is the language about intentional discrimination. And Kathy argued that by terminating her tenancy based on the criminal acts of domestic violence perpetrated against her, the housing provider intentionally discriminated against her on the basis of sex by denying her the opportunity to rent this unit and adversely affecting the terms and conditions of her tenancy. The complaint also raised disparate impact theory, and it alleged that the complex had used this zero tolerance of crime policy in a way that was discriminatory against domestic violence victims and therefore had a disparate impact on women. Kathy had asked, when she received the eviction notice, there were negotiations to try, of course, and stop the eviction. And somebody from the corporate department of this particular property management company said that they had a policy that any time a criminal act occurs in a unit, the entire household must be evicted. And so Kathy was challenging that policy under disparate impact theory. And so in her complaint, that she argued that by adopting a policy of holding tenants who are domestic violence victims responsible for the criminal activity of their abusers, the housing provider engaged in a pattern and practice that had a disparate impact on women because the majority of domestic violence victims are women. In addition to filing that affirmative federal litigation, Kathy's attorneys used a media strategy to get her story out to the public. And you'll see on this slide there's an excerpt from an article that was published on the Chicago Tribune's website. And once this story appeared in the Chicago Tribune, it really took off nationally and got national coverage. And shortly thereafter, the case settled. The property management company, which is called Aimco, is now required to abide by the terms of the settlement agreement at all of its properties, which are nationwide. So if you ever have one of these cases involving an Aimco property, it's good to know that there is a settlement agreement in place that probably restricts AIMCO's conduct toward victims of domestic violence. I believe that settlement agreement is confidential, so I haven't seen it, but I would imagine that one of the provisions in there is that they not discriminate against victims of domestic violence. The other thing about this case is that it prompted the state of Illinois to enact an eviction defense for domestic and sexual violence victims. And you'll see the citation to that statute here. And if you want more information and want to view the full complaint, there's a link to the Shriver Center's website so you can look at the great work that they did in this case. So I'm now going to turn it over to Sandra, and she's going to talk about the advocacy that was done in Tanica's case.
Sure. So as you all might recall, Tanica's case involved the property damage that was caused when her ex-boyfriend broke in, and the landlord holding her responsible for the property damage caused by her, quote, guest. So in response to that, we sent a demand letter to the owner alleging that their conduct violated both the Federal Fair Housing Act as well as the Michigan law that also provides for fair housing, and argued that the landlord's conduct was both intentional discrimination because it relied on a gender stereotype as well as disparate impact. And the gender stereotype we cited in the letter was that basically the landlord was saying that Ms. Lewis was, anytime a domestic violence survivor could be blamed because she was responsible for the acts of the abuser, regardless of whatever conduct she had done to protect herself, including in this case taking out a restraining order. And so the stereotype that was in operation here was that somehow domestic violence survivors are always necessarily at fault or somehow invited or allowed the abuse to happen. And so that was really the basis for the disparate treatment or intentional discrimination claim. In terms of the disparate impact allegation, really what we argued there was the landlord interpreting the word guest to somehow include people who were not invited, and in this case actually restrained from coming to the property, had a disparate impact on domestic violence survivors and certainly on women as a result of that. There was a third legal argument that was raised regarding the low-income housing tax credit nature of the property, and I'll just quickly mention that that program actually prohibits evictions unless there's good cause. And so the argument we made there was that an eviction based on domestic violence, an eviction of the victim based on domestic violence can never constitute good cause. So that was a new argument, but something that you might want to consider if you are also dealing with a low-income housing tax credit property. So the letter got sent. The owner did not respond, and so at that point there was a federal lawsuit filed. And the case ultimately settled with several different parts of the settlement. The most significant part from our perspective, as well as Tanica's, was the adoption of a new policy by both the management company and the landlord that restricted the landlord from obviously discriminating against individuals based on their status as victims of domestic violence, dating violence, sexual assault, or stalking, but also offered some affirmative relief for tenants who are facing this abuse. So in the state in which this case was brought, Michigan, at that time there was not any state law provisions relating to early lease termination. I think that's now changed, but at the time there wasn't that kind of protection for victims of domestic violence who needed to leave their property early. And so as part of the settlement agreement, the management company agreed to offer early lease terminations to survivors of violence, as well as the option of relocating to one of their other properties if a unit was available. And that was only really feasible in this case because the management company operated several dozen properties in the Detroit and also Ohio areas. And then there was also an agreement as to monetary damages and attorney fees. I think like in Kathy's situation, there was extensive local news coverage of this case, and that certainly helped lead to the settlement because of the negative publicity the management company and landlord received. So I think we're going to just wrap up with some takeaway points and then definitely take your questions and other comments at the end. And so here we just wanted to summarize some of the strategies for using fair housing laws for survivors. So along with Tanica's case and Kathy's case, I think one of the lessons we've learned is the need to advocate with housing providers to adopt policies that address the needs of survivors of domestic and sexual violence. And I think one point of comparison here is that in the employment arena, there have been many, many years and lots of efforts to encourage employers to adopt sexual harassment and other policies. Also more recently recognizing the needs of domestic violence survivors who are employees. But I think there's been much less work done with housing providers. And so this is an arena where I really think there's a vacuum of advocacy in terms of educating housing providers about how their policies could better address the needs of tenants who are survivors of violence. In terms of when you actually have cases of discrimination, we advise that you would consider raising the Federal Fair Housing Act as well as state and local laws in terms of legal allegations, as well as the Violence Against Women Act if the client is living in public housing or Section 8. And in response to some of the questions, I just want to clarify that the Federal Fair Housing Act applies to private housing as well. There are those exceptions that Malia listed in an earlier slide for smaller properties and other small exceptions. But that overall, the Fair Housing Act is the legal protection for private housing, as well as, VAWA does apply to private housing if the client is participating in the Section 8 program. Another takeaway point we wanted to emphasize is that if you are contemplating filing a complaint with HUD under the Fair Housing Act, to really read HUD's memo about how to frame those complaints and also to frame them as sex discrimination claims. I've been surprised to see recently some of the pro se complaints that have been filed with HUD that a lot of times people do not realize that when they're being discriminated against based on domestic violence, that may well qualify as sex discrimination. And that's something also that HUD has to be better educated about, because many times tenants will directly call the HUD hotline and describe their situation, but might not know what category of discrimination their situation falls within. And so it's both, I think, an educational endeavor with HUD, and that's hopefully something the FHEO memorandum will really go a long way in doing. But also with clients themselves, that recognizing the connection between domestic violence and sex discrimination is an important one to make for them. The other issue here, of course, is, as we discussed before, to also think about whether a claim of race or national origin discrimination makes sense in the particular context. So we've been talking a lot about framing these claims as discrimination against domestic violence survivors. One thing that we really do want to emphasize is that these theories are still relatively new, and so we have some great guidance from HUD on this, but that we really encourage you to reach out to Malia or myself if you're contemplating bringing either a HUD complaint or a case, because we'd really love to advise you further on how best to do that. There's still precedent really being developed in this arena, and so it's really important to carefully think through how these cases should be framed. Also, as Malia had mentioned, it's important to build contacts with fair housing groups and pro bono attorneys that can take fair housing cases. I think that there are local fair housing groups in most jurisdictions that will be interested in these cases. But I think sometimes those collaborative relationships have yet to be developed, and so if you see clients who are presenting these issues, to make those contacts is an important step in further advocating for them. Also, that a media strategy can often be useful in these situations. It's always a sensitive issue and something you need to talk about with clients who are domestic violence survivors about whether engaging in the media makes sense for their personal situation. But as we discussed with Kathy's situation as well as Tanika's, The media can play a helpful role in highlighting the injustice that's going on if there is a provider that's discriminating against a survivor. And lastly, to reemphasize the point that Malia made about sexual harassment cases, the need for special outreach to survivors and partnering with sexual assault advocates when you come across a sexual harassment case. And I think just as a preliminary point that, in general, when you see a tenant who may be facing a housing issue or maybe facing eviction or maybe choosing to leave her housing, just look further in terms of screening to see whether domestic violence or sexual harassment is at the root of why she's facing the particular housing problem that she has. We just know statistically that oftentimes housing issues for women are highly connected with either domestic violence or sexual abuse. And so to really get at the heart of why she's facing this particular issue is an important one, to even be able to identify what legal rights she might have in that situation. And then the last slide just has our contact information. I just want to mention that the ACLU does take cases for representation. So while I'm based in New York, oftentimes we will take a case partnered with our local state affiliate. So feel free to reach out to us both for technical advice and possibly for consideration in terms of actual representation. So I think now we're going to open up for questions.
Right. So I'm going to look through some of these and see if we can formulate some answers. All right. So I see a question. If a survivor is living in a private complex and is not using Section 8 or other government monies for rent, can you still make a HUD complaint? And the answer is yes. One thing that I'll note is that in states who have a fair housing law that is substantially equivalent to the Fair Housing Act, they will often have their own state fair housing agency that will investigate fair housing related violations. And so even if you file the complaint with HUD or if you file it with the state agency, the two agencies talk to each other and your complaint will get to the correct agency. But in some states, HUD will only handle complaints regarding subsidized housing if there is an equivalent local or state agency that takes fair housing complaints. But in any event, again, if you file your complaint to HUD, you're in private housing and HUD thinks that the state agency is the more appropriate agency to investigate the complaint, HUD will refer the complaint over to your state agency.
So I note here there's a question about the Fair Housing Act and shelters or transitional houses that might have rules that may be discriminatory against a group. And on this question, I want to refer you to a great fact sheet that the National Law Center on Homelessness and Poverty has put out. And I actually don't recall the title of it. I don't know, Malia, if you do, but they have a fact sheet sort of laying out all the laws that may govern the conduct of shelters, and that's a valuable resource, I think, for shelters. I think there have been a couple of cases, maybe not specific to domestic violence shelters, but shelters overall, from many years ago, but I guess if you want to give more specifics about what you're thinking about, we might be able to address it further, but I commend that fact sheet to you in terms of the legal obligations of shelters.
Yeah, I agree with that. And so their website is www.nlchp.org, and on the left-hand side, I believe there's a column or section on domestic violence, and if you click there, you should be able to navigate to that fair housing fact sheet for shelters. We've gotten a couple of questions about the application of these Fair Housing Act theories to male survivors of domestic violence and whether you can use the same theories. I think with disparate treatment theory, there definitely should be some cases where it would apply. If a housing provider, for example, use some sort of stereotype against regarding male survivors of domestic violence. So, for example, if a housing provider said, I don't believe you because you're a man and men are never victims of domestic violence, so, I don't think this was related to domestic violence at all. I think you just made a mess of your unit. That could be an example where you're able to raise a disparate treatment claim under the Fair Housing Act. And then, Sandra, I don't know if you have any additional thoughts regarding that.
Yeah, I think that's very right. And it could be, for example, let's say if there is a landlord that might favorably treat domestic violence survivors, or at least not punish them, if they're not applying that same policy to male victims of domestic violence, I think you would make out a case of unequal treatment there, because that policy or practice should be equally applied regardless of the sex of the victim of domestic violence.
Right, and I think maybe what the questioner is getting at is I've never seen this happen, or I've never seen this type of case litigated, but I think you would have maybe some difficulties, of course, raising disparate impact theory because we don't have the statistics correlating the incidence of domestic violence among male survivors. The statistics we talked about earlier showing that the majority of survivors are women are not going to be able to make a case out that a policy that discriminates against DV survivors has a disparate impact on men based on the high correlation of domestic violence and sex. And Sandra, I don't know if you have anything else to add to that.
Yeah, I mean, I do think that's one of the, gaps with using the fair housing disparate impact theory in terms of male survivors or same-sex survivors. And it's one of the reasons I think that many advocacy groups have been very interested in ensuring that either at the state or federal level that there are protections for survivors of domestic violence and sexual assault as a protected class, rather than trying to use these sex-based theories, which sometimes don't really fit the situation.
Okay, and thanks so much, Sandra. Somebody has asked me to repeat the website for the fair housing resources as they pertain to shelters. That website is www.nlchp.org, the National Law Center on Homelessness and Poverty.
So there's a question here about whether there have been cases litigated involving transgender DV survivors. And as far as I know, there have not been in terms of the fair house and the context that we're talking about with respect to discrimination based on domestic violence status. Whether there are unique issues or applications, I certainly could imagine that there might be, depending on the specific facts of the case. And really, some of the sex discrimination theories often turn on what perception the landlord has of the person's sex. And so in a transgender situation, depending on sort of what the landlord is perceiving and how they are treating the tenant accordingly, I think the way those theories might be applied could vary. But if you have a specific factual scenario in mind or a client you're working with, please feel free to reach out to us and we could talk more about that.
Great, thanks. Somebody has asked, how can a city's Fair Housing Commission, what can they do to prevent the fair housing rights of domestic violence and sexual violence survivors from being violated? And a couple of things I could think of is you, as an advocate, might want to give the Commission a copy of the new guidance that HUD has issued on domestic violence and fair housing and ask them to distribute it to housing providers in their jurisdiction. Another thing you could ask them to do is that to the extent that they're doing fair housing trainings with housing providers, ask them to please include a component on domestic violence and sexual harassment as part of those general fair housing trainings. I think in a lot of jurisdictions that's not happening right now. I'm just looking through the other questions.
So there's a question about the average time period of a Fair Housing Act lawsuit to settlement. So of course that really varies, and there's obviously no guarantee of settlement. So you know, it often varies very much depending on the federal district court, if you're in federal court, or the state court that you're filing the lawsuit in. And so I would say typically, you know, it's not a very fast process. It's going to be likely a period of a year to more years in terms of actual resolution. And so this is definitely a factor that, you know, clients need to keep in mind in terms of pursuing actual litigation. The HUD complaint process can also be somewhat lengthy, and I don't know if you have a better idea there, if there's a more uniform time period that people can expect those to be resolved in. Malia?
Unfortunately, I don't. I think the bottom line is really this often is not going to be speedily resolved, whether you're pursuing litigation or whether you choose the administrative route. The administrative route also might depend on how quick your own state housing agencies are at processing fair housing complaints. But unfortunately, we can't give you a black and white answer about the time frame, but just to note that this sometimes can be a lengthy process in order to get your client the relief that she needs. All right, I'm just looking to see if there are other questions we could answer with the remaining 10 minutes or so that we have. Somebody has asked, what about the cases where the Fair Housing Act doesn't apply, such as the cases with owners who own small properties? And in those cases, one option I could think of is to look at state law remedies, look and see if your state fair housing law is more expansive than the Federal Fair Housing Act and does cover those smaller property owners. The other thing is to look at your state law and see, is there sort of a cause of action for wrongful eviction or evictions that violate public policy? Because arguably, well, really, as an advocate, I believe that evicting someone based on acts of violence committed against them would certainly be a violation of public policy and would constitute a wrongful eviction. So I think in those instances, maybe thinking creatively about your state law remedies and seeing if there's some sort of relief that could be had there.
There's a question about whether there are pamphlets available for victims who have been evicted from housing and what kinds of recourse they might have. So I think there are materials both on the National Housing Law Project website, and then I know on the ACLU website we have a Know Your Rights pamphlet that's directed to survivors, and so that is certainly a resource. I believe it's in both English and Spanish and is available for download there.
Mm-hmm. Right. So definitely check out both of our websites for those materials. Somebody has asked for clarity on hostile environment sexual harassment. They want to know, is it an action that happens against the tenant or is it something that's happening around them? Sandra might also have something to say about this. I think the courts have sort of varied in their interpretation of what really does constitute a living environment that's so hostile that it amounts to the level of actionable sexual harassment. Things that they look at, first of all, if there is unwanted touching, I think the courts treat that much, the standard is not as high versus if there are just comments of a sexual nature made against the tenant. In those cases, if it's just comments, the court is going to look at how frequently were the comments made. It's really, unfortunately, a fact-specific inquiry, so it's hard to provide a lot of clarity on what actually does constitute hostile environment. On our website, there's an outline on sexual harassment that discusses some of the hostile environment cases. So that might be helpful so you can see some examples of what a court has actually found was hostile. But instances, another thing that courts look at is also whether the employee or landlord entered the tenant's unit and therefore violated their sense of security. That could rise to the level of being so severe as to constitute hostile environment, sexual harassment. And Sandra, I don't know if you have anything else to add about that.
I think that's really complete. It really is a fact-based inquiry. Quickly, there's another question about that fact sheet we referred to, and I found the title of it from the National Law Center on Homelessness and Poverty.
Oh, great.
It's called Questions and Answers, Domestic Violence Shelters and Civil Rights Statutes. So hopefully that'll help you find it on their website.
Somebody has asked, what are the implications of discrimination against domestic violence survivors who are limited English proficient, and do they have additional remedies? Those survivors, in addition, to being able to raise the sex discrimination arguments, he might also have a claim of discrimination based on national origin if the housing provider has failed to provide services in the survivor's language. Particularly if it's a subsidized housing provider, because they often have some responsibilities to provide translation or interpretation in the tenant's language. Again, though, it's very important to look and see if the housing provider is getting any type of subsidy. Other things, HUD has said that maybe if a housing provider is only providing services to people who speak English, or refuses to rent to households who don't contain a family member who speaks English, that could constitute disparate impact on the basis of national origin. And also, one other thing I'll add is that it's our understanding that HUD is planning to issue some guidance probably in the coming months on limited English proficiency and claims under the Fair Housing Act.
And I was just going to mention in the VALA context, HUD has made many of its domestic violence-related forms available in different languages on its website. I don't know, do you have a link to that on your site, Malia?
I think we do.
Okay, I think I saw it.
The other thing is that, so the VALA form is called Form 50066. And if you go to HUD.gov/HUDclips and look for Form 50066, they'll have a link to their limited English proficiency website where you can download the other languages. All right, we're still just looking through the questions to see if there's anything else we can answer in our next 2 minutes, I guess. Somebody asked, how can we find out about fair housing laws that a specific state might hold? With regard to laws that specifically affect domestic and sexual violence survivors, there is a compendium on our website at www.nhlp.org, and there's also a link to the compendium on one of the slides that was a part of this presentation, and that includes all the laws that affect domestic violence survivors. In terms of just general state fair housing laws that each state has, I know there must be a good resource out there for that, but I can't think of anything off the top of my head. So if anybody knows of a website that lists all of the state's fair housing statutes, if you could enter it in the question box, we'll read that over the phone. But otherwise, unfortunately, I can't think of a great resource on that right now. All right, so I think we've about answered all the questions that we can during our time together today. But I really wanted to thank all of you for your great comments and questions throughout the webinar. And as I mentioned, we'll send out an evaluation after the webinar is over that you can fill out online, and we do appreciate any feedback that you might have. Additionally, I'll send out the materials once again to everyone who registered for the webinar. And the recording of the session will be posted on our website probably within the next 2 weeks or so. So again, I wanted to thank my co-presenter, Sandra Park of the ACLU Women's Rights Project, for all of your helpful tips and suggestions today. And with that, that concludes our session. Thanks, everyone.